That was mean.
It was mean.
It's very important.
It started.
All right.
Be quiet. It's
All right, can everyone hear me? Can anyone hear me?
Yeah.
Okay, great. Um, okay, I think we're gonna get started, and if more people join, I'll just let them in. But thank you guys so much for coming to our first event and to hear an incredible topic lecture from Sarah. And yeah, I'll let Sarah take over.
Okay, thank you, Abby. So I'm Sarah. I'm a senior at Greenhill, and I primarily debate in LD. I've already debated on the plea bargaining topic. Like I know it's been a little bit, and the topic has already, gone on for a little bit, like a little under a month. So this will be a little bit more of a recap, and talking about my thoughts on the topic that maybe haven't been, like implemented in debates yet. So let me share my screen and see if you guys can see this. Okay, can people tell me like in the chat or something that you can see this? Okay, yes, I think people can. So if you can't, if there's any like technical difficulties, like let me know if like you can unmute and say them. And if you have questions, save them until the end. I'm gonna do like a designated like question time. Okay, so this is the September-October topic lecture. And the topic is in the United States criminal justice system, plea bargaining is just. So, for some things we're going to cover, we're going to figure out the weird stuff first. So, this topic is obviously not like others. So, I wanted to establish what those differences actually are and how they impact debates that we're going to have on the topic. Because, there's not like a verb or an agent in the topic, which is a lot more different than other LD topics. The next thing I want to talk about is topicality because I think it, sets the ground for what negative ground is, for what AFs can do. And then I want to talk about AF advantages. So I'll go through policy AFs that have been broken on this topic, fail AFs, and KAFs. And then I'll go through negative positions. I'll start with disads, then counterplans, then like fail NCs, then the K, and then at the end we'll have time for questions. And if you have any questions during the lecture, try to pop them in the chat and I'll like periodically check. Okay. So the first thing I actually wanted to show everyone was this diagram of the criminal justice system. So this topic obviously has to do with the CJS because plea bargaining is part of it. And I think you can see like the the plea process is just like a fraction of what this whole process is. This is like what a person's, time would look like from the beginning of like when they commit the crime to when they get out of the system. And plea bargaining happens right around here, like the arraignment process. It's right before adjudication. And so it's like one small portion of this like larger web, but they're all super interconnected. And I think people should think about this and sort of figure out ways to like, make the topic work such that maybe you can like make arguments about any of these other portions of the system and how they relate to plea bargaining specifically. So we should establish some groundwork first. Plea bargaining is a negotiated agreement in a criminal case where the defendant pleads guilty or no contest to a criminal charge in exchange for some concession from the prosecutor. And basically, if someone gets charged with a crime, they can forego their rights to go to trial and be deemed guilty or not guilty and just admit that they were guilty or like admit to the charge, basically. And this admission of guilt would get them something like a reduced sentence or drop charges, but they would go to jail like for sure, guaranteed. So basically, you're just like admitting to a crime and saving the courts the trial process. And so, what does it mean for things like due process? So, due process is obviously a right that is established in the Constitution that says that, people have the right to a lawyer, like a legal defense, and a speedy trial, and a jury of their peers. But the important part is they have a right to trial. Plea bargaining is literally a violation of that. I don't know if it's a violation because people like, consensually agree to the plea process, but it means people give up their right to due process in exchange for making the system go quicker. And when you think of things like due process, they're pretty like integral to the American criminal justice system for sure, right? Like we think about all these civil liberties and rights that are bestowed upon us. Plea bargaining is a way to sort of like violate those liberties, but is still you making a free and informed choice. So there's a few types of plea bargaining. The first one is sentence bargaining, and that's when people bargain for like a reduced sentence. So, if I commit like a murder, for example, but I plead guilty immediately rather than, the prosecution having to develop a case, I might get a reduced sentence from that. Another type is fact bargaining, where people have to bargain to have have incriminating facts of the case dropped and disregarded. That could also mean that the prosecution no longer has like those facts to establish a higher sentence or a higher charge. So those things exist. The next thing is charge bargaining, when people bargain for dropped charges. So, like oftentimes when people commit like large like money laundering crimes, they have lots of different like crimes or charges that they have, like, when they go to court. Some of them can get dropped if they decide to pursue a plea deal. Additionally, there's also types of plea deals. Those are distinct from types of plea bargaining because those affect like the outcome rather than the process of negotiation. So I don't really think the topic is like specific to this, though I think people will want to talk about types of plea deals. A guilty plea is obviously when you plead guilty to a charge. A no contest plea is when you abstain from admitting guilt specifically, but you accept the charges. And an Alford plea is when you explicitly say that you did not do the crime, but will accept the charges anyway, as to not have to, go through the process of like, hiring a lawyer if you can't get access to a good like defense or something. I don't know. Like people sometimes do that. And so I think an important thing for people to think about when they are approaching this topic is that over 95% of criminal cases are currently involve plea deals. So most of the time when people are charged with crimes, they don't actually go to trial. Like they don't sit in like a courtroom that we see in like movies and stuff. They accept a plea deal and just like go to jail. This is actually particularly bad for AF inherency. So obviously, like inherency, the idea that AFs have to defend a departure from the status quo. But if plea bargaining is a status quo, then AFs really can't defend a change from it like they normally do. This has tons of implications around the topic. I think this is actually like the most important fact about the topic, which I'll get into later in the lecture, but it affects things like topicality, AF ground, negative ground, like everything. Even I think the way that judges should like adjudicate debates. Okay, so there's some other weird things that are going on with the topic. First, there's not a verb or an agent. This means that AFs don't really meaningfully do anything. Like I guess they could. There are like interpretations of the topic where people can defend a hypothetical world where plea bargaining is increased, or a hypothetical world in which they are defending the existence of plea bargaining. But at its very minimum, AFs can pretty much defend the resolution as a value statement or a truth statement, which just looks like, in a vacuum, like in the United States criminal justice system, plea bargaining is just as a truth statement. So I think AFs can work around this through the framework debate, through like the framework for the debate. So one, there's, comparative worlds where you can imagine a world in which plea bargaining exists, and I think that this would allow for AFs to defend a more material implementation of the resolution, but also truth testing can be strategic as opposed to comparative worlds because it's grounded in the resolution, and since there's not like a world we defend, there's not a verb or an agent, so there's not really a reason to defend comparative worlds, and that can also help against counterplans and critiques when you're AF because people like to make arguments that under truth testing, alternative advocacies don't negate because they don't prove the falsity of the resolution. They just prove that there was like some other option that's good. Second way that AFs can work around this is definitions of justice. So if you can frame the debate around something that's like, the definition of justice, that's more material or focused on like implementation strategy or scenario planning, then I think you could defend AFs that, would like defend plea bargaining as material good. Though I will say I think that's actually kind of unstrategic. I think AFs like a most ideal AF in my head on this topic would defend plea bargaining as a truth statement, because I would pretty much delete like all good negative positions other than like the K probably. I.e., we would defend plea bargaining as a legal concept, but not actually its like real implementation because there are other things that make it bad. But in a vacuum, plea bargaining is pretty good. I think AFs can say that because it was intended to solve whatever impacts AFs are saying. And I think that also makes it really hard to be negative. So a question to ask yourself is, when you're negative, how will you force AFs to defend, what you want them to defend? Especially when it comes to alternative advocacies. People have to think and be really creative about counterplan competition, which I'll explain more like later. But those kind of stuff, like that kind of stuff you have to think through. Okay. So I like to begin every topic lecture with a discussion of topicality because it informs the rest of the topic. The core controversies we have here are one, does the AF get subsets of plea bargaining? So can AFs defend plea bargaining for certain individuals? Can they defend plea bargaining, like different types of plea bargaining, like sentence, fact, charge? But the second thing is what are types of plea bargaining that are legitimate? So like within subsets, which types of plea bargaining are okay for AFs to defend and which ones are unpredictable? Third is can AFs defend reforms to plea bargaining? So, plea bargaining in the status quo has a lot of negative implications. Can AFs get around that by defending other reforms? And so I've put a list here of like things that I think AFs can probably reform, public defender reform, all of those things that like have implications within the plea bargaining process. And I think smart AFs can like, maybe bake one of these into the AF mechanism. So, in terms of like topicality arguments that I've seen so far, the first one is T in, where like the negative would read a definition of in that means throughout, rather than like within or in something. And that in means throughout means AFs have to defend plea bargaining throughout the whole criminal justice system, which means that they can't defend like plea bargaining in a specific like for a specific type of person or a specific type of plea deal because they don't exist throughout the system. Now, the obvious flaw here is that like plea deals do not exist throughout the entire system, so like no AF would be topical in a sense. I just like think it's a bad definition to use when it comes to like subsets, but I've seen people do it. The second one is TD, where people say like V is a definite article, and that means that it has to be the entirety of the thing that it modifies. But I also think this is a pretty bad argument. It just like doesn't have to do with the topic. So people like make it their subsets interpretation, but I don't know. D doesn't modify plea bargaining, it modifies criminal justice system in the resolution. So it doesn't pertain to all plea bargaining. So after under that interpretation, I think could still defend subsets of plea bargaining. The next one is like T CJS, that the CJS includes all of its activities or agencies. I think this one is slightly better because it's grounded in like, like the terms of art in the resolution rather than like the word in or the word the, right? But still, it's not that great. And my real take here is that there's not a stable word in the resolution that you can define when you're negative that like is a good subsets definition that like, makes like limits AFs. Really, I think people should be making these like more theoretical arguments because just topicality is weird. Similarly, when we're AF, it's also kind of hard to find counter interpretations of plea bargaining that say that like you can defend subsets of it. Like no verb or agent means AFs don't do anything, so there's not like a thing for you to define of what AFs can do. So a lot of these are just like theoretical arguments. I think the best AF, like when you're AF, obviously you want to defend smaller affirmatives because they're just like, more strategic. They allow, like they link to less negative positions. And I think the strongest piece of offense here in topicality debates is picks. People say that like, defending whole res AFs means that AFs will lose to picks, that every subset AF becomes a pick and AFs can't generate deficits against them, which means they lose. And I think this is actually particularly compelling on this topic because since like the resolution is the status quo, it's much easier for when you're negative to find a pick out of something that already exists rather than a pick, from a change to the status quo. So like think about it this way, if that was like a little confusing. Like on previous topics. So let's take last year's like wealth tax topic. It's much harder to find a pick out of a wealth tax which no longer exists because that would require someone to be writing about a wealth tax and then writing about like an amendment that we should make to a wealth tax, right? That exists, but it's like a little difficult to find. On this topic though, people can write about like flaws with plea bargaining all the time. So the amount of picks explodes because plea bargaining is status quo. People are writing about it. And it's hard to generate deficits because AFs aren't doing anything. They're just defending a value statement. So you can't be like, there's a deficit to defending the value statement one because that's like it's just incoherent. And I think the real trick here is that like you have to say picks don't negate. They're not competitive because AFs are just a value statement. But that debate gets a little messy. I just think picks is like a really, really good AF standard on this topic. There's also picks out of different types of plea bargaining, different individuals, different cases, like plea bargains in this specific court case was look bad. That also similarly can become an AF. So an AF can be like, plea bargaining in this particular instance was bad, so plea bargaining is just. And there's like obviously debate to be had of like does that really affirm whatever? That's a topicality debate. And I think it's super contentious on this topic. So I think really like the people who will be winning the most topicality debates are the ones who can theoretically justify their interpretations through like reasons why they would make the topic more debatable. I think definitions are just like really bad for me, I think. Unless you get into like a nitty-gritty grammar debate, which no one wants to judge. Okay. So next for apps here, basically there's they're like all pretty bad if they affirm the resolution in my opinion because I just like they absolutely have a stable mechanism in order to like do things. So let's just talk about like the content areas real quick. For policy apps, so apps with like extinction impacts, the most common advantage that I've seen like is in the literature is a court clog advantage. And basically, the argument here is that plea bargains speed up the process of like the courts. You can incarcerate like way more people if you do plea bargains. They're like they're the foundation of what American courts are built off of. We wouldn't be able to prosecute nearly as many people like need to be prosecuted without them because there's and I think that it's just like plea bargaining really speeds it up because it means people don't go to trial. People automatically admit guilt. And so when you imagine a world without this, it would lead to like way less judicial efficiency and legitimacy. Our courts would be so behind. So that's just a concept of like court clog. The impacts of this are a lot of things. I've seen people read an impact to judicial legitimacy that it controls the internal link to basically everything because the courts run everything. There's also warming impacts, democracy impacts, disease impacts because courts also a lot oftentimes, like the even though like criminal and civil courts are separated, oftentimes it would be like, judges share like, judging burdens for both criminal and civil cases. The same courthouses sometimes are used, even though like in a lot of places they're distinct. But they could prevent key warming legislation from getting passed or erode democracy, like faith in democracy, because it would be like the perception that our courts are declining, um, or like other impacts or whatever. And so that's one of them. The second one is an app advantage about the economy, where it says that like we should sort of incarcerate corporate crimes. So people who commit like money laundering schemes and stuff they should like accept plea deals and go to jail because oftentimes the trial process for corporate crimes like when people commit like really high up money laundering crimes and stuff it's difficult for jurors or even judges who are like not experts in that field to like make informed decisions when it comes to that because it's just like so complicated a lot of the time and it incentivizes things and like current mechanisms to check corporate crime are not sufficient. Like people can get through them. Plea deals, however, would be able to resolve all of those things because it means that they would like automatically admit that they're guilty and they'd just go to jail. And so people say that it resolves things like, antitrust crimes or corporate crimes and would be able to uphold the economy because it means people like aren't committing fraud, or whatever. There's also different types of apps that have to do with like certain types of pleas. So there's an app about like insanity pleas. There's apps about fictional pleas, which are just different types of pleas that exist in the literature. I'd encourage you to do research about like different types of pleas that you can defend. But those are fair game if you can defend them with topicality. There's also like reform apps that would reform plea bargaining. People like, they might be extra topical, but they definitely exist in the literature. There's types of plea bargaining that happen within like communities where community courts like you can think about like mutual aid for example. Those courts, incentivize people to like admit to guilt so they can go be rehabilitated for example. And so those types of apps are also interesting on this topic because you can make arguments for why that's considered within the realm of the US criminal justice system. Okay, the next type of app that I want to talk about are PhilApps. And the really important distinction I think here is ideal versus non-ideal theory. So this is like two camps of philosophical thought that exist. Ideal theory says that we should approach philosophy from the perspective that the world should be like in its perfect form, that good things would exist in the world, like if something is good, if it would exist in an ideal world. So like here it would like for the plea bargaining topic, it would be plea bargaining is good because in an ideal world, plea bargaining would exist. It would increase the legitimacy of the courts. Like as a principle, plea bargaining is good. Non-ideal theory says that we shouldn't like, think about the most perfect world and then build up to it, but rather we should work with what we have, and like recognize that the world is not ideal right now, and see if in that non-ideal world would plea bargaining do good things. So I think there's like an obvious split between like which one goes AF, which one goes negative. I think if you're a Phil debater and you're saying like, a Phil AF, you should obviously say ideal theory is good. And if you're like going up against Phil debater, maybe you can say like non-ideal theory is good. Because plea bargaining is like pretty not I because in our non-ideal world, plea bargaining is pretty bad. Like it forces people to admit guilt, oftentimes crimes they didn't commit. That is like I'll get to that on the negative section of this lecture. Like when we talk about like negative positions. But yeah, so in an ideal world, though, plea bargaining might exist because, it makes the courts more efficient. It allows people to admit guilt to crimes that maybe they did commit, and stuff like that. So I think a big AF on this topic, like a Phil AF, is a contractarianism AF. And basically what this says is that plea bargaining affirms because it sort of embodies a social contract principle. And it leads to things like mutual benefit between the defendant and prosecutors and everyone involved. And it also is voluntary, like a voluntary agreement, and also incorporates like the rational choice to maintain a social order. All of those things are like really big principles under contractarianism. They're like the big author here, I think, is like Gauthier, I think is how you pronounce his name, Gauthier. And basically like that's why I would affirm. I think you would need to win like an ideal theory lens in order to win it. Another big fill-off I've seen is legal positivism, which I know less about, but like is definitely an argument that people have said affirms. But this important thing about all of these fill-offs is that it only like works if you win the system guarantees like fairness, such that the contract is genuine rather than coerced. And I think a lot of negative arguments straight turn fill-offs. So like my real position here is a lot of fill actually negates. But people like, fill-offs still exist to some extent. But I think it's pretty easy to negate them. The last thing here are chaos. And so these are apps that obviously like critique the topic to some extent. I think those are actually pretty good because plea bargaining is pretty bad. Like K-links are really good. And so there's a couple here. One is like the abolition critique. These I'll explain it more in depth when I talk about like how to say the critique when you're negative. But it basically just says that we should like, abolish the CJS or sort of like adopt that as like a practice for our research. And then we, can begin to create a more fair and more just system, or more fair and more just punitive and rehabilitative spheres. There's another sort of camp of critique literature here, which are like critiques of like legal theory. So like Sept-Oct has links to legal theory or capitalism or like really any camp of like critical literature has critiques of the law and like critiques of courts, etc. Those things I think are like pretty good. Okay, next we can talk about negative arguments. I actually realize I can't really check the chat when I'm like giving the lecture, so just save your questions till the end probably. Yeah, okay, so negative disadvantages. The first thing I want to say here is you need uniqueness counterplans if you want to go for like a disad with a material impact. Why is this? Because AFs are the status quo. Disadvantages are thus always non-unique if you do not have a uniqueness counterplan that yachts the opposite direction or the opposite thing. So like what does this mean? The ban counterplan is pretty good because it says that we should ban plea bargaining and then the disad derives a unique net benefit off of the fact that we've banned it. So that means AFs can't say like the disad is thumb, the disad is non-unique because the negative is winning a world in which plea bargaining would ideally not exist. So I think you need uniqueness counterplans in almost every disad debate. So the most common disadvantages I've seen, the first one is civic engagement, which basically says that plea bargaining decreases like people's ability to be involved in things like jury trials or like their involvement in the system because it's just seen as like super like automatic. Like you just accept the plea deal and you go to trial. And then there's like some impact to that. I think it's just like democracy. The next one, is the Constitution's DA that says that plea bargaining is unconstitutional. I kind of touched on this a little bit earlier when I talked about how plea bargaining like violates like the Fifth and Sixth Amendments to due like rights to due process. And yeah, it would be like pretty bad in that arena. Then if you would talk about how like the existence of plea bargaining would erode the constitutional rights, to, like destroy civil liberties, and then like similarly lead to a democracy impact. The next type of disadvantages that I've seen are mass incarceration disadvantages, which basically say that like plea bargaining leads to mass incarceration. Like obviously, like most Fs will have to bite the bullet on this one because like the whole point of plea bargaining is to efficiently funnel people through the justice system and like get them like not make them not go to trial. So they would inevitably facilitate things like mass incarceration. A lot of the impacts of these are things like disease and warming, because when people are like cramped up in close quarters because like of mass incarceration, disease can spread a lot quickly, and then they can get like transmitted outside through like prison guards and stuff. COVID was actually like rampant in many of America's like jails and prisons. Warming impacts also come up because it, like costs a lot of like energy, like to upkeep prisons and stuff, which oftentimes leads to like a lot of burning of like fossil fuels and whatever, and that could lead to some warming impact. The next type of disadvantage that I've seen that I think are pretty interesting actually are modeling disadvantages. And the literature is like surprisingly good about this. So it's basically just like, plea bargaining in the United States gets modeled in other countries, so other countries will adopt it. The most common thing I've seen in the literature is like Nigeria. So Nigeria adopts plea deals, or like other countries with less stable democracies, accept plea deals, and then that destroys their court systems because they're just not as efficient. They don't have like the resources to upkeep them. And then that leads to like civil war or regional conflict in those places. So like U.S. like criminal or U.S. Plea bargaining specifically affects those areas. And I think that gets you to external impacts that apps can't really access, because they're obviously about like international countries. The last thing I want to talk about here is politics, like politics disadvantages. I've seen people read them. They're pretty like people get creative with them because since apps don't really like defend anything, there's not like a bill getting passed. If there was, plea bargaining is the status quo, so it's not like it would change anything that hasn't existed forever. But people I think have said that like tough on or like the like plea bargaining is perceived as tough on crime. Like that's bad. That will like lead to like people like losing political legitimacy or like, political capital, losing elections, etc. I don't like politics. I think is weird on this topic. I genuinely don't think it exists, but there are people like the ways that people have gotten creative with it. Okay. Next thing here is counterplans. So I touched on this a little bit when I talked about uniqueness counterplans, but you pretty much need them, I think, for most like uh, disads and stuff. But for counterplans that are um, like external to the plan or external to the app, you need like competition. Competition is weird because there's not like a verb or agent. There's not like an ought word, like a word ought that people can get competition off of. So I think the alternative word in this topic is. That is means like in the present tense as it is in the status quo. And counterplans would change something about the AF or change something about the status quo. So like that's the competition argument there. Um, there's I think advantage counterplans like are pretty good on this topic because AF internal links are zero. There's like no shot that plea bargaining is a key internal link to like every impact that AFs will say they are. Like I mean people should cut good evidence, but I just think that is much harder to come by on this topic. Advantage counterplans solve them pretty well. The next thing here is process counterplans. Again, there's like not really a stable basis for competition other than like the word is, or sometimes like the word the, because like or maybe the word just. People will say like just is unconditional, or requires like immediate effect or something. But there's not really like a process that you can conduct over types like over plea bargaining because it already exists. I've seen a lot of counterplans repeal plea bargaining and then do some process and like re-implement it through that process. I think that's fine. I still don't think it's that competitive because, plea bargaining, like in the USAJS in a vacuum can be just, but it could also be amended and we can do other things to it to make it more just. I don't think like external processes like net benefits derived off of that necessarily compete with the F. I just think this topic is weird, but people have like gotten creative with it. The next counterplan that I think is good here that I didn't really put on the slide is the ban counter plan. That basically just like bans plea bargaining or like bans or like sort of bans like the process within the criminal justice system itself. And implicitly within that bans plea bargaining because it like, kind of negates the entire CGS and then also just gets some net benefit off of anything from like the 2020 policy topic basically, which is like reforms to the CGS. So it competes because it doesn't do like plea bargaining, but also gets like an external net benefit. And they are all obviously all you have to answer is like, perm do the counter plan and like still do plea bargaining, but like there's answers to it. I think it's pretty good because like AFs don't have game against it. The last thing here are picks. So picks are also like exist on the topic. I think I talked about that a little bit more on the topicality slide, but there are lots of picks that exist. So, for example, the drunk drivers pick says that, we should have plea bargaining for everyone except drunk drivers because they should go to trial and not experience reductions in their sentences because they made the voluntary choice to do that. There's the sex crimes pick that says that people who commit like sexual offenses or sex offenders should not be able to bargain for a reduced sentence or a reduced charge because they like obviously committed an egregious crime and should not be let off like that. The next one is like the police pick that says that in instances of police brutality, plea bargaining is unjust, but in every other instance it's just because police commit like acts of brutality against civilians sometimes. And the last one is Alford pleas. I think I touched on that a little bit earlier, but Alford pleas are when you explicitly admit that you do not do that, you didn't do the crime, but you will accept the charges anyway. People say that it can lead to things like human rights abuses because people are coerced into saying coerced into accepting the plea deal even when they explicitly did not do it, which is basically a pick out of innocent defenders, really. And I think the big thing here is like picks are pretty good theoretically because there's like a ton of groups of people and a ton of types of plea deals that are probably bad, like to have plea bargaining for. But competition is weird again because none of them are really textually competitive. There's no way to exclude all of the words in a meaningful way. Like obviously people change one word here or there. I still don't think that's textually competitive. And so people just have to get good at justifying that theoretically. I think it's pretty easy to because there's just simply no other way I think to write those texts on this topic, which means the neg just wouldn't get picks, and picks are probably good. Okay. The next thing here is fill. I talked about this a little bit earlier, but most fill negates. The reasons for this are because plea bargaining is like kind of inherently coercive. So the way I think I've alluded to this a lot in the topic lecture, but I'd like to sit on this and explain it here. Is oftentimes like when defendants go to get plea bargains, they are under this thing called like a lot of prosecutorial discretion. And what this means, prosecutors have a lot of bargaining power in these plea deals. Defendants are often told that they do not have a chance if they go to trial. They'll get convicted for their crime, potentially something even worse, and their sentence will be egregious. And so they're often coerced into accepting the plea deal because they're like, oh, well, I'm screwed. Like, there's nothing more I can do. And even if they didn't do it. So in a lot of times, like people are like, even though I didn't do it, the jury's gonna convict me guilty, the case looks convincing against me, I'll just accept the plea deal. And that means they're waiving the right to due process for no reason. They're getting nothing out of the situation other than like hypothetically getting reduced sentence. So really, like in practice, plea bargaining is pretty inherently coercive. The next thing here is that plea bargaining violates the Constitution. Again, I explained it before in the dissad slide, but it's like promise breaking. The Constitution is a promise that is bestowed upon to like all the constituents and citizens of the United States. Plea bargaining violates that, which is bad. I think these two things that I explained are both offense, like under for continency, for example, but are also offense for like a lot of other Phil authors that, albeit I don't know a lot about, but like very confident most Phil negates. The last thing I want to say here is that SCEP affirms, because if, like SCEP obviously triggers presumption, because it provides that there's like the AF has not met their obligation of proving a moral obligation. That's how it exists on like most topics. However, presumption means that you presume like the status quo, and the status quo is AF. So, SCEP affirms, I think. So, yeah, food for thought. Okay, last thing here, the topic, the critiques of the topic. I think this topic is like really good for the K because AFs are the SQO, so K links are really good because oftentimes all the K teams and a lot of bad K teams, like on previous topics, win some link to the status quo, or like win ontology as a reason the state is bad, so the app must be bad. And I just think it's a lot harder to get game versus apps that defend, a change from the status quo because you get to defend whatever you want in that change. Like you can make that world your own. But apps here, a lot of them do not defend like anything past the status quo. And that's good if you want to answer like a disad, for example. Not so good versus the K, because like most critical authors are talking about why the status quo is bad, like why systems of criminal justice are implicated in racial systems of control. That's bad, leads to like bad impacts. And so, um, do with that as you will. Fiat doesn't exist, importantly, on this topic because, apps don't do anything again. So the Fiat K, unfortunately, does not exist. Fortunately, unfortunately. But that also means that framework is more important than usual. I think a lot of K teams can win based off of like excluding app offense with the role of the ballot and making education arguments about why in the context of like a CJS topic, learning about like the systems of like dominance and control that are imbricated within the CJS is good. And it's good for students to learn about those things. So I think framework is really important and people should spend a lot of time researching their framework cards. This is also true for when you're reading a KF, like researching like cards about debate, cards about why talking about the CJS is good. Similarly, I think AFs should be a little like a bit more like afraid of the critique this time, or try to build in mechanisms to their AFs that are able to have game versus the critique, and I think also have implicit defenses of why defending the CGS is a good idea, and makes us more equipped to like maybe tackle it on in the future, or critique the CGS in the future. Like defending it in high school and like learning those perspectives is good. I don't know, it's just something that you should think about. So when it comes to like what camps of literature exist for the K here, abolition is the biggest one. I think it's one that like most people on the topic are reading. And it, again, I think it basically says that the criminal justice system is irredeemable. It requires like violations of humanity in order to exist. Requires things like forced prison labor, police surveillance, and like systems of control that are bad. That we should abolish current criminal like proceedings, like the system writ large, and then replace it with things like life-affirming institutions. So like mutual aid, communities of care, rehabilitative programs that work from the ground up instead of like a state-sanctioned punitive like system that like just maybe leads to things like mass incarceration, leads to the overcriminalization of Black and brown folk, leads to the like overcriminalization of like single mothers, etc. And makes it more difficult to be a minority in the United States. So a lot of authors write about this. Dylan Rodriguez is the biggest one, though he's kind of like deviated a little bit from like the abolition lens today. He wrote about it a bunch in the past and like wrote a bunch of really good cards. The next one is Angela Davis. She was a prominent abolitionist who rose to like prominence during the 1990s, like sort of the beginning, the genesis of the abolitionist movement. The last one is Tommy Shelby. He writes a lot about abolition as well. So I think, researching these authors for K-links to pretty much any critique, because I think they talk about like why they have a lot of like they write about plea bargaining, a lot of them do, and they also write about why like the broader system is bad, and those can be used as K-links for other critical literature as well. And so the other types of critical literature that exists on this topic are satcol, capitalism, anti-blackness. I think those are the most like common ones that people read nowadays. And set for settler colonialism, people make a lot of arguments about why the courts are like inherently colonial, why they like replaced indigenous forms of control or like indigenous like tribal systems, and that's bad. They also like people also read like cards about why plea bargaining is just like inherently racist, overly prosecutes indigenous groups, etc. The next one is capitalism. This I think the thesis of this argument is pretty similar to like the abolition K that says that prisons are designed to like reinforce neoliberal systems of control by shuffling people through them quickly. Things like prison labor, for example. So that's when like prisoners go to like prison and then they work. They build license plates a lot of the time. Like a lot of license plates that you see on the street were like manufactured by prisoners, or like they built them. Also things like hand sanitizer. They like make a lot of the hand sanitizer for prison labor. All those things are really bad because they get paid like it's like 10 cents an hour. It's like way below the minimum wage, and it's like basically a form of like slavery that they do. And plea bargaining necessarily reinforces it because it like is designed to shuffle more people into the system. So people make arguments about why plea bargaining leads to things like capitalist systems of control. Um, the next thing here is like the anti-blackness critique. So a lot of the time, like plea bargaining as an institution is probably inherently racist. A lot of cops hang around historically black and brown communities because they know they'll accept a plea deal and they'll refuse to go, like they'll waive their rights to go to trial because prosecutors will make it seem as though they have like no like defense. And like sadly in our world today, like jurors are way less like lenient towards, like racial minority groups. And so plea bargaining is especially bad for them because it, like waives some of the only tools that you have at that moment to be able to escape things like prosecution in the future. And so those are basically like my broad thoughts about the critique. I think it's pretty good. I think the weakest part here is probably like alternatives, and I think AF should like, open that up. And I think good answers to the critique on this topic is that just like AF's in a vacuum as a justice statement, like in the US CJS, plea bargaining can be just, and all of the other external things about the CJS can be unjust, but that doesn't mean that plea bargaining is bad. So the way that I sort of like it sounds kind of confusing, but the way that I explain it in debates is that like you should think of the AF as a conditions AF, for example. In the event that the USCGS exists, plea bargaining would be just underneath it because it would allow for people to, reclaim trials into their own hands rather than it being like, in the hands of a prosecutor or a defendant. That doesn't mean that CGS is good. That just means in the event that it exists, plea bargaining would be good. So I think that's a little bit distinct and is a smart way to sort of like think about answering the K on this topic. Okay. That's basically all my thoughts about like AFs and negative positions. So if anyone has any questions, I'm like open to hearing them now and I can answer them. Okay, actually, I got a question in the chat that said, how do you frame the debate that you are defending the ideal slash in a vacuum? So I think the way that you should frame this is that basically you can just say that like the topic itself says that in the CJS, plea bargaining is just. So we should imagine a world like a world where plea bargaining is employed as a legal instrument. And I think there's a lot of ways you can say this. You can say the topic justifies it because it says like there's no verb or agent, so you can just defend it in a vacuum, like as a truth statement. The second thing you can say here is that it's more debatable because plea bargaining is the status quo. Negatives get like so many like links to disads and critiques and whatever. It's just so easy to be negative. So defending it as a legal principle is a lot more debatable for the AF. So I think there's both like resolutional arguments you can make, but also arguments about like theoretical arguments about debatability that I think are pretty good. Does anyone else have any questions? You can unmute as well. Okay, I got a question that says, what do you think I should focus on for traditional tournaments or AF and NIGARGs? I think a lot of them actually apply the same. So you can make, on the AF, you can make arguments about why plea bargaining increases like court efficiency and judicial legitimacy and upholds like our courts. And those are the key things that we need to function like in a healthy democracy. When you're negative, I think you can say like a structural violence argument, like plea bargaining retrenches structural violence against like black and brown groups like I just explained before. I think that's a pretty good argument. I think you can also say that plea bargaining is coercive. It prosecutes innocent defenders. Those are all like negative contentions that I think like implicitly answer a bunch of AFs and are pretty good. Does anyone else have any questions? Yeah, I think we're good, Abby.
Beautiful. Thank you all so much for coming, and thank you, Sarah, very much for um helping with our first event. I will post this recording on the Slack and on the Instagram, in case anybody missed any part of it or would like to go back. Thank you all so much for coming. Have an incredible topic.